right, it's morning huddle time. Good morning.
No, I'm not saying it works.
I wish you
I'm just saying
Godspeed.
it happens.
I Godspeed with all of that. I think that's really, really nice. I'm not sure what kind of success you're going to have with that today, because the world, my friend, has changed.
Right.
Latin American construction workers, they have different needs. They have completely different needs.
These awards have a huge criteria that you have to fill out, and they usually have a community service or community relations portion.
Makes them, the most productive with a high performance value, and sometimes it's 11 o'clock at night.
Yeah.
Funny, isn't it? Yeah, not for me.
Not for me.
At 11 o'clock, I am guaranteed to be snoring. So. Good morning. It's morning huddle time. I'm Chad Prinky. I am remote today, working from a hotel. Hopefully my internet access holds up. I'm with Stacy Holzinger as always. Stacy, how are you this morning?
I'm doing good, and I'll stay on just in case.
Yeah, that's right. Stacy's here to have my back in case the internet in Kansas City fails. Yeah. So, and we have today with us our guest, Jackson Nichols. Jackson, thanks so much for joining us.
Thanks for having me, Chad.
Yeah, it's great to have you here. So Jackson's a construction attorney. I'm going to let him provide a little bit of context for sort of who he is and how he got to where he is. But I've known Jackson, Stacy and I both known Jackson for several years as a go-to resource for contractors in the DC metro area when it comes to all things legal, trying to navigate the changes and challenges that they all face. Jackson, maybe if you would give us a minute or so of context on who you are, how you got to where you are, and where your point of view might be coming from.
Yeah, sure. Thanks, Chad. So my name is Jackson Nichols. I'm with the law firm of Cohen Saglius, Palace Greenhall and Furman. I'm originally I'm a North Carolina native, born and raised in Raleigh. Moved to DC in the late 2000s after law school, and I've been here ever since, practicing law since 2006. I've been focusing mostly on construction law since 2015. And I practice in DC, Maryland, and Virginia. We have a lot of owners, contractors, GCs, and subs, and pretty much anyone in the industry that we represent. And my law firm is a national practice, mostly concentrated in the Mid-Atlantic region, the Northeast. But we represent people in the construction industry all over. And like you said, there's a lot of changes. There's a lot of challenges in the industry. And sometimes we're in court duking it out. And sometimes we're kind of behind the scenes helping people with strategy and figuring out, what to do with the latest challenge.
If I can speak for every owner of every contractor that I know, being in court duking it out is definitely the last thing we want to be doing. But it's really nice to have somebody that can help you to do it if it absolutely has to happen.
Yeah, that's definitely true. And that's always our goal, is to avoid litigation. There are times when you don't really have any choice. And there's some times where you have to credibly threaten that you're willing to go all the way, even if the dollars are not quite there to make sense for that. But same risk calculus for the other side. So, but you want to stay out of court because it's expensive.
Yeah, it's expensive. And I think also a crazy distraction, right? Like you need to be building stuff. Mm-hmm. You don't need to be sitting in court litigating the past, if you can possibly avoid it.
Yeah, that's a great point. It's not just the dollars. It ties up your resources. It ties up, it's an emotional toll on people. I mean, litigation just gets very all consuming. And you can delegate it if you're the owner of a company to like the project manager who is involved in that project, and they're taking care of a lot of it, but it's still going to be hanging over you, and usually for a long time. I mean, it takes a long time for the whole process to play out, and we always try to get our clients to settle cases where it makes sense, and get a good deal and get out and move on with doing what you do, which is construction.
Yeah. Yeah. All right. So I've got all kinds of questions. Let's dive into this thing. And, I, I think from a starting point, I'd just like to ask, what are the reasons? Let's go all the way into litigation for a minute. What are the reasons? What are the most common reasons that we're in court? Just it probably seems like an obvious answer, but I want to hear, from a professional on it. What's the number one reason that we end up in court?
Well, as far as my practice with representing construction companies, usually it's a dispute over money. Sometimes there can be seeking to obtain something called injunctive relief. You might try to, get a lien bonded off or something like that. But usually you're fighting it out over money, and that could be a fairly simple contract balance dispute. But they can get progressively more complex. Change orders, scope disputes, that's getting a little more complicated, a little more factually intensive. Then you might have construction defects. You might have a delay claim or delay schedule related type of dispute. That's getting on the kind of higher end of complexity.
Yeah. Yep. That makes total sense. I mean, at the end of the day, those different circumstances that you talked about do come down to money, but we're probably not arguing over money if there's not something a little bit more nebulous or, complex at the heart of the issue. Because if it were as simple as you owed me X, you didn't pay me Y, we probably wouldn't end up in litigation, right? So the circumstances that really, I would imagine, end up in litigation are the ones where each party feels they have a legitimate claim to their position, right?
Yeah, absolutely. Sometimes you have to make a business decision, but sometimes parties can get dug in a little bit on their positions because they know they're right about something, and they know that the other side is just kind of jerking them around, and they don't appreciate that. And so it's a tough tightrope you have to walk sometimes, because you want to make sure you're being a good business owner and you're doing what's in the best interest of your company as far as the dollars. And sometimes, you've got a $80,000 contract balance claim, and that's not nothing, but that's not worth paying a lawyer for over a year to pursue. So, people do get their emotions involved in it, and that's a factor. And there's also a rational component to that as well. I think you want to create a moral hazard sometimes, and sometimes it's worth it to say, hey, we're not someone that can get pushed around out there.
Right. Yeah. I mean, and that is one of the things that is kind of special about the construction industry. It's probably not the only industry where this is the case, but certainly not all industries are the same, in that the construction industry is one in which you're going to be doing business with the same people, with the same sort of, folks, from year to year, from decade to decade. These people, and unless you're a traveling contractor that's all over the country or the world, the majority of contractors are local presence. They build a certain kind of building. And if they're working with owner X or general contractor X today, they're going to end up working with probably those same humans, if not those same companies, again in the future. So that's an interesting take, like that comment that sometimes you need to, you're making an investment just to kind of prove that you can't be pushed around.
Yeah, no, that's definitely true. And because of the very integrated nature of the industry and how it can be very local a lot of times, and kind of where you're doing your work, that is a big factor sometimes that we take into account when we're deciding whether or not to push forward past just a demand letter stage. Do we want to really file a lawsuit against this company, or do we want to lien this project when we think we've got another project with them, or we want to get more business from them? I mean, that usually kind of informs your decision and might make you decide a little earlier, okay, well, let's just take, 70 cents on the dollar here instead of 90, and
Right.
just kind of cut a deal, because we'll be seeing these people again. And, people talk in the industry too. You don't want to be that contractor that's tough, that gets a reputation for being tough to work with. And, everybody has to do horse trading from time to time. That's kind of the project management process a lot of times.
Yeah. Let's start to walk backwards now. Like, how do we end up here? And how do we keep ourselves from actually experiencing the level of dispute that rises to the question of, should we actually press forward into litigation? So from the very start, the moment I'm imagining that leads to that triggers the first recognition of a potential problem is that moment when you were supposed to be paid and you're not being paid. Let's focus on that one, because I'm guessing there are, I know there are a few others, but let's focus on that instance. You should be paid on something and you're not being paid on it. How quickly would you raise the alarm that, we don't need to just wait, but we need to be proactive and communicate and say, hey, what's going on? We're supposed to be getting paid.
It's a great question. And I think if you asked different construction attorneys, they'd all give you a slightly different, but holistically mostly the same answer. You don't want to wait too long, and your decision needs to be informed by first of all, what's the language in the contract, your construction contract, whether it's you're a GC and it's your contract with the owner, you're a subcontractor, it's your subcontract with the GC, if you're a supplier, the purchase order, whatever. Second, you're going to really want to know, whatever state you're in for that project, what are the other kind of statutory protections that are there for a construction contractor who's trying to get paid. Right. So there's going to be very kind of specific timing deadlines that are going to vary a lot from one state to the next. And most of those are, if it's your general rule of thumb, if it's a public project, it's going to be a bond claim. And your timing is usually going to be 90 days from the last day you did any work. If it's a private project, then it's probably going to be a lien claim, a mechanics lien that you could file, because that gives you extra leverage beyond just the your breach of contract lawsuit, which you can generally file within a longer period of time. But when you're the downstream contractor, you don't have that extra leverage, and those statutory enforcement mechanisms, lien claims, bond claims, that gives you an upper hand, because usually the contract is stacked against you. And because the terms of the contractor tend to be less favorable for you, there's been a long time recognition in the industry that legislatures need to step in and level the playing field a little more. So that's why you have lien claims, and those can vary pretty widely in the timing. So I would, for instance, Maryland says you have to file a notice of a lien claim, not a file. You just send it to the other side and to the owner within 120 days of your last day of work. So, that's a slightly longer period. Virginia, it's, it varies depending on whether or not the project's been completed, but it's usually 90 days from the last date you did any work. Then DC is also 90 days from the last day that you did any work. So you might be hearing the commonality here, which is if you're done with the project, then you really don't want to be waiting. If you're done with your work on the project, then the clock starts ticking at that point. Right. Whereas if you're still working, you might have a little more time.
But and correct me if I'm wrong, but if you're still working, you also have some leverage, right? Like on some level. If you're still working, your leverage is pay me or I stop working.
Yeah. Well, yes, but we usually recommend against stopping work, because there's usually going to be a provision in the contract that says that even if there's a dispute, you have to keep doing the work.
Right.
And even if there's not, it's really important that the contractor controls the work that's within their scope. And just because the other side, let's say the other side saying, you have to do this, it's part of your original scope, and they, the contractor knows that they're right. This is not part of the original scope. This is definitely a change order. But you know what? That you should probably do it anyway, because if you don't do it, then the upstream contractor, the owner, whoever it is, they're going to have someone else do that work, and then they're going to hit you with the bill for it, and you're going to have to figure out who's right eventually, whether it's a court or an arbitrator or the parties just kind of work it out in settlement. But they're going to hit you with a bill that might be a lot bigger when you could have done the work for a fraction of that amount. So when you do the work yourself, you control the costs a lot better. And you've got a larger claim now that you can assert for payment.
Right. Wow. Okay. So, my take is, and I'll just speak for the trade contractors or the downstream contractors, as you've been calling them. I'll go with that here for a minute. What I always recommend is that on day one, after you were supposed to be paid, you should be finding out what's going on. That's all. Simply just finding out what should be going on. And in fact, go rewind back to the moment that you submitted that invoice. Directly after submitting that invoice, and we're talking days, not weeks, directly after submitting that invoice, you should be confirming that it was approved.
Yep. Absolutely.
All these are just ways to sort of keep you from finding yourself in situations where you've been not paid for a long time on something that, the further out that gets, to your point there, depending on if you've stopped work, there are actually ramifications on whether you can even get any satisfaction on that. You can even get paid on that. But also I think just fundamentally, like, what it's going to do is surface conversations about problems potentially while you still have the ability to do something about it. Is that, it sounds like you agree, but I'll toss that over, to your, what's your view on that?
Yeah, well, I think it's important that you create an overall project record. And protecting the project record is very important when the terms of the contract are less favorable to you, because you want the facts to be on your side as much as possible. And if you're talking about something a year ago, it's like, well, yeah, me and the superintendent for the GC had this conversation, and he definitely approved that work. It's like, well, if you didn't write it down, then it's hard to say it happened. People's memories change. Now things are hinging on the credibility of your project manager or someone else as a witness. So it's really important you create this project record. And that's true for both changes to the work, but also the expectation of payment. So when you're sending frequent emails or even a letter from the owner of the company saying, hey guys, we're 45 days past due, we really need to get this paid, you're protecting yourself with that project record. And I think that's an important aspect of it. I think that's just one of those many little things, like you talked about, Chad, like confirming the payment application's been received or confirming that it's been approved, just little things like that you can do to create a good record for your company.
Yeah. And man, just demonstrates how you're 100%. I think that makes total sense to me. And it almost barely enters into my reasoning for doing it. Right? My reasoning for doing it is like, if there's a problem, you want to know immediately. You don't want to find that out, 60 days later and be like, wait a minute, why haven't we been paid on that? You reach out and they say, well, your invoice was wrong in this area, and this area, and this area. Mm-hmm. And now you've actually, because at the end of the day, what I think we should strive for is to create open, transparent, healthy kinds of, relationships with everyone we're working with. We shouldn't want there to be conflict or contention. And so, and therefore, I think it's incumbent upon everybody to take steps to prevent that. And communication's the key. And then also, you need a record if things get bad.
Yeah, and you can you can make that record in a way that's not adversarial.
Right.
You can do it in a way. I mean, your contract literally requires you to provide notice of any changes on site that you come across. You have to notify the owner, or if you're a sub, you have to notify the GC to notify the owner. Like, they have to know about that so they can react. So you're just doing what you're supposed to do under the contract, and you can do it in a very professional manner. Yep. But it's also very important to protect your company, and also to kind of set expectations of the relationship, of your partnership with the upstream contractor or entity that you're dealing with, that, hey, we need to get paid on time. We're not going to just stand for waiting 120 days for our invoices to get approved and get payment. That's not okay.
Yep. We've heard a lot in the past year about changes happening in the Mid-Atlantic region, at least, with pay when paid, pay if paid. Can you give us a crash course of what this all means and what the latest changes are?
Yeah, so pay if paid and pay when paid are two slightly different concepts that sometimes get conflated. Pay if paid means that if I don't get paid, then you, downstream contractor, I have no obligation to pay you for that particular work. So it's and there usually has to be strong language in there that's very specific. The magic words have to be used. Usually it's a condition precedent. Payment downstream payment from the owner is a condition precedent for the GC to pay the subcontractor. So if there's never any payment by the owner to the GC, then the GC doesn't have to pay the sub for that work. Pay when paid means within a reasonable time. We don't have to do it. If we don't get paid, then we don't have to pay you at this time. But after a certain amount of time, and no one knows exactly when that is, there's going to be an expectation that it has to get paid, and a legal obligation at some point. Now, as far as the trends, well, there are some courts that there's some states that have said that we're not going to allow these contingent payment clauses to be enforceable. A lot of courts will enforce them because, parties are expected to be able to contract freely. They're all sophisticated commercial entities, and you can abide by the terms that you agree to. But some courts have said, well, we think this is so unfair that we're not going to enforce it. And some states have actually said that we're not going to allow this as a practice in the industry because it's so unfair. And right now there's roughly, I think last I checked, there's about a dozen states that have said that contingent payment clauses are actually void as against public policy, or they have some way of saying that those are not allowed. And actually, Virginia is the most recent entrant to that new trend. Just last year, Virginia passed a law that took effect as of January 1st, 2023, for any contract signed on or after that date, that pay if paid is no longer permitted in Virginia. And that's, of course, having ripple effects throughout the local industry here. Everyone's still trying to figure out how to react to that. It's not unheard of over here on the East Coast. North Carolina and South Carolina also have similar prohibitions. But it's a big deal, and our GC clients are trying to figure out how to deal with this in Virginia, because it puts a lot more pressure on them.
Well, yeah, they're shouldering. It's such a challenging topic to, from my perspective. General contractors are shouldering an undue burden there if they are on the hook to pay subcontractors regardless of whether the owner pays them. Simultaneously, I'm happy that the subcontractors gain a level of protection, because they're the ones who are extending all of the all of the funding on materials and labor. I mean, they're the ones that are shouldering this burden, and to not be paid absolutely puts them out of business. And we see it happen far too often, where a good trade contractor is on tilt because they're not being paid. So on one level, I'm glad that has a recourse, that shouldn't occur. On the other end, I'm like, who's holding the owner accountable? Like when does which law holds the owner accountable? How do we make that happen? Are there any trends toward you know pushing the responsibility further up the chain?
Well, I mean, it's a great question, and it's a question that different people are answering in different ways as we speak right now. I mean, it's a statutory risk shifting mechanism, and it's moving the risk a little bit upstream towards the GC. But the owner already has risk. If it's a private project and the subs are not getting paid, the owner can always have a lien filed on it, whether it's by the GC or by one of the subs or whoever else is allowed to under that state's law. So the owner always has an interest in making sure that that doesn't happen, and they'll try to protect themselves by having, lien waivers and things like that. But the GCs need to probably adjust their language in their contracts a bit to maybe they were giving more favorable terms in the past to owners because they wanted to be a good trade partner, they wanted to have a good working relationship. And maybe they want to drive a harder bargain now on some of those contract terms that keep a little more risk on the owner. It might be that they do the same kind of risk shifting behavior with their practices with the owner, where they just are a little tougher about prompt payment with the owner. I've heard of more creative ideas, people talking about like owners having to post their own bonds, things like that. But that's certainly interesting.
Is a subcontractor who is being told by the GC that the reason that they're not being paid is that the GC has not been paid, is a subcontractor potentially jeopardizing their relationship with the GC by putting a lien on the building?
Well, you can jeopardize your relationship with the other party for any reason. But yeah, I mean, that's always some kind of, that's always an issue, but the contract does require you to be paid. And the law says that you can't use that as an excuse anymore. Now, it's interesting. The lien is actually a way at least in DC and Maryland, to get around pay if paid, because you can still lien a project even with pay if paid law, or pay if paid being enforceable in that jurisdiction. So you can always get around it that way.
It just doesn't put the pressure on the GC. It puts the pressure on the owner.
That's right. That's right.
But I guess what I'm saying is, if you're a subcontractor and you're sitting there and you're sort of saying, we're 120 days out on a change order that's equivalent to 20% of the contract value that I had on this project, and the general contractor's telling me that they can't get this thing approved by the owner, am I committing a kind of business suicide by putting a lien on the building? In your experience, is it that potentially damaging?
Yeah, it is potentially, and it's part of the tough calculus that contractors have to take. So if they've got a smaller contract balance amount, they might decide, all right, let's just work this out through the claims process and through the negotiation process, and we can always just file a lawsuit, a year or so down the line. But if you wait too long, you're letting your lien rights or your bond rights lapse, and that's dangerous. And you don't want to just be filing liens on every project.
Right.
I've heard of some people that do that. I personally would not recommend that, because I think that you really have your future business relationships.
It goes to reputational damage, as you mentioned before. Yeah.
Yep.
Yeah. It's I really think that, I've seen this in one or two different situations where the subcontractor will actually go to the general contractor and say, listen, I'm hearing you and you're telling me that there's no way you can get me paid. I'm about to put a lien on the building, but I want to make sure that doesn't come as a surprise to you. And I want to make sure that that's not going to, cost us our future relationship. And I've actually heard that conversation go far better than expected, because in a lot of situations, the general contractor kind of looks both ways and says, do it.
Yeah,
You know?
yeah. No, the heads up is a great way to handle that because everybody understands it's a business, and you got to pay your own employees and for the materials, and you're out of pocket for that. So they understand that, and if they see it coming, then they have to kind of deal with it like that.
Yeah, and I think what I have found in watching a lot of those conversations, from a perch, right, from a third party remove, what I have found is that the vast majority of subcontractors, or I'm sorry, general contractors, are not the reason that the sub's not being paid. It's almost always, if the GC is not paying the sub, it's because the owner's not paying the GC, and the GC has no interest in making that sub's life painful unless that sub is in some way not upholding their end of the bargain.
Yeah, yeah, and it can get messy. There can be there are things that the sub didn't do great, and then they're fighting over whether or not there's a justifiable back charge. It can get complex pretty quickly. But yeah, a lot of times the owner is the one kind of holding the bag, and sometimes the owners aren't as sophisticated within the construction space, and getting them up to speed on some of the practices of the industry is a challenge for the GC as well.
Right, right, totally. Yeah, I can imagine it, and in fact, I've seen that too. I can't believe I could talk about construction law for 30 minutes and totally forget what time it was. Jackson, this has been a lot of fun. I want to toss it over to Stacy to see what questions we might have to add on specific before we jump off.
Yeah, I have 3 quick questions for you. Hopefully we can get through them. Casey had a great question. Pay if paid is not enforceable in Virginia, but some area GCs are putting in their contract that the venue for legal issues will be in Maryland. What advice do you offer subs when presented with a subcontract for a project in Virginia with the venue as Maryland?
Well, so that's just a venue provision. And that may or may not be enforceable depending on the circumstances, but that doesn't mean that just because you're a Maryland court, Maryland would still, could still apply Virginia law. So venue shifting provisions can be different from choice of law provisions, and I think that might be what Ike is getting at with that question.
So if I could say this maybe in a different way, and Jackson, you tell me if I got it, we're kind of saying like the laws of Virginia still apply regardless of whether you're in a court in Maryland. However, in a court in Maryland, you may bump into a judge that is more, more versed in, maybe more lenient toward that. Is that right, or correct that?
Well, it could be that. It could be that the GC in that situation is just trying to give themselves an argument that the Virginia prohibition on pay if paid doesn't apply because we're in Maryland. But I would, it's a new statute, so we don't know how courts are going to interpret it, how that Maryland judge is going to interpret it versus a Virginia judge. But that's I would expect that even if there is a choice of law provision saying that Maryland law will apply to this contract, I think there's still an argument that the Virginia, because it's a Virginia project, that pay if paid applies. But maybe a judge would disagree with that. It kind of comes down to how they interpret laws, and laws when they're written have to be interpreted by judges and applied to different sets of facts.
Yep.
So what % of cases make it to litigation?
I would say, what's our starting point? I'll just assume that we have a dispute over payment or something like that. And I'll often get pulled in, not too late in the dispute, just to try to help resolve things. Maybe I'll be more behind the scenes, or maybe I'll step in and send like a demand letter or something. Once it gets to that point, I would say actually more than half of the time it gets worked out without a lawsuit having to be filed. And sometimes, and a lot of times you'll file the lawsuit and things will settle right away if the dollars make sense.
Yeah.
The general rule of thumb, once a lawsuit gets filed, is that roughly 90% of all cases settle before going to trial. And sometimes I've had cases settle on the courthouse steps. I had a trial up in Northern Maryland a few weeks ago. It was a jury trial that settled on like the fourth day of the trial. So you'll see that happening as well. Cases settle all the time, and it's usually in parties' best interest, their business interest, to control their own destiny. And even a deal that is not ideal is better than one where you have a lot of risk and a lot of uncertainty.
How long do the cases usually drag out?
It could, I mean, once you file a lawsuit, I'd say the general rule of thumb could be a year or two, but sometimes you're in arbitration. A lot of construction contracts require arbitration, which honestly is not a terrible way to do it because it's usually less expensive. You have to pay a little more money for the arbitrators, but you're probably going to have a shorter discovery schedule. It's going to be a little more targeted. And one of the important things is the arbitrator you pick, you can select someone that knows construction law. And that means that you're not spending a lot of time educating a judge about construction law and educating a jury about construction law. That's an uphill battle right there. I mean, juries are smart. They get things, but you're going to have to put in a lot of work to educate them. And that, that's just more resources you got to use on that.
Yeah, that makes sense. Final question would be, can you discuss the characteristics of a good case versus a bad case?
I would say one of the most important things you can do, Chad and I were talking about this early on, is what thing that strengthens your case the most is having the best documentation. So you want to make sure that you're, following the terms of your contract and you're documenting that you're doing that. And if the other party is trying to push you around in ways that are outside of the terms of the contract, well, you're going to look a lot better by documenting that you're trying to stay within the contract, because you can kind of cloak yourself in the protection of the contract terms and its procedures. And also you can prove that whatever you're doing, if you're writing it, then presumably it's good for you. Well, if you're better at documenting what's going on, then your side of the case is going to sound stronger when someone else who's neutral is looking at it 1, 2, 3, 5 years later. So that's always helpful for you. Consistent, reliable project documentation is critical.
Yep. And not just for some projects, do it for all.
Yeah. Not just don't start doing it once things get a little dicey. You should always be doing it.
I hear that all the time, where I'll be like, you better start documenting. I'm like, you should have been documenting this whole time, guys. Like now is not the time to start. It actually almost in some ways looks worse when all of a sudden you start doing it. But anyway, Jackson, it's been a pleasure having you on. Thank you so much for bringing value to our audience and providing a really interesting a discussion, certainly for us. So we were glad to have you and look forward to having you on again in the future.
Thanks a lot, guys. It was a pleasure.
Thanks. Have a great one.
You too.
All right, Stacy, let's talk a little bit about some housekeeping items before we wrap up. So I think the first thing that I want to call out, and I know we've talked about it a couple of different times, but it is fast approaching. We will be running the live NAWIC conference podcast on May 5th, Friday, May 5th, around midday. So keep your eyes peeled for that invite coming across, whether you can join if you can be at the NAWIC conference in DC, please do. I think that would be awesome. We'd love to see you in person. But if you can't, you'll have an opportunity to tune in live, get a little bit of a feel for what's going on at that conference. Is that right, Stacy? Everything that I just said sound accurate?
That's accurate.
Awesome. Good. So I look forward to that opportunity. And if you're there, who knows, we might just drag you onto the screen. Yeah. Sorry, that's not don't let that deter you from coming.
Only if you want to.
Only if you want to. That's exactly right. Next week, we've got episode 50, which also wraps up this season. And episode 50 is with Phil Key, who is the president of Rupert Landscape. He's going to be on talking about actually a bunch of different things, but I think the main theme is going to be how to operationalize your culture, how to take something like a company's core values and what we're really all about and what we, what we try to be, and turn that into actually, a daily set of habits that everyone knows, and it isn't just a bunch of BS. So Rupert's done an incredible job of that, and I think very few people better to talk about it than Phil.
Yeah.
So that'll be cool. Look forward to having that. And then finally, as always, we will hope to hear from you on getting added to our mailing list. Email Stacy at stacyh@steeltoecom, that's 2Ms.com. And obviously we're building our next season, which will start August 1st-ish.
Let me see.
Ish, right? Ish is okay.
August 1st. Yes, you're correct.
All right.
We already have guests lined up for August, some for October even. So September, we're looking at a lot of new topics for this season. We try to do new topics each season, so it's not the same repetitive things. So a lot of
even if you don't have like an idea for a guest, an idea for a topic, we'd love to hear.
Yeah. Anything that we missed so far that you haven't heard would be great.
Agreed. All right, cool. Well, I think that does it. Stacy, thank you. It appears I made it through without any glitches.
Yeah.
I will give 5 points to the Hyatt. 5 points to Hyatt for having good streaming Wi-Fi. So, all right, Stacy, have a great week. We'll see you next week.
See ya.
See you, everyone. Bye-bye.